So we're diving into a case today that really makes you question what a marriage actually is, in the eyes of the law.
It's a fascinating one. We're looking at Rathnamma versus Sujathamma, a Supreme Court judgment that starts with what seems like a simple family dispute in Karnataka.
Right, but it's so much more. It's this collision between a modern bureaucratic document and ancient religious custom.
Exactly. You've got this young woman, Sujathamma, and she has what looks like a slam dunk piece of evidence. It's called Exhibit P1.
A marriage agreement, stamped, signed, and registered at a government office.
In any other context, say under the Special Marriage Act, that piece of paper would probably be the end of the story. Case closed.
But not here, because this was a Hindu marriage, and that's the whole twist. The couple, they just skipped the wedding ceremony entirely.
No rituals, no fire, nothing. They just went to the sub-registrar's office, signed this agreement, and that was that.
And then, just 8 months later, the husband dies. Sujathamma goes to claim her share of the ancestral property as his widow, and the family just says no.
Their argument was simple. A signature doesn't make you a wife.
And, amazingly, the Supreme Court ultimately agreed with them. Which really gets to the heart of it all, the difference between a contract and a sacrament.
Yes. This is where we have to talk about Section 7 of the Hindu Marriage Act. It's not just a guideline. It explicitly states that a Hindu marriage must be solemnized with customary rites and ceremonies.
And the court was super specific about this, right? They called out the Saptapadi.
The 7 steps around the sacred fire. They said without that, or an equivalent core ritual, there is no marriage. The registered agreement is just a piece of paper recording an event that legally never happened.
That's so interesting. I think most people assume registration fixes things, that the government stamp makes it all official, regardless of what came before.
It's a common misconception. The court clarified that registration is only evidence of a marriage. If the marriage itself is a nullity because the core rituals were skipped, then you're just certifying nothing.
So the paper proved they wanted to be married, but not that they were.
Precisely. And that was only their first problem. The lack of a ceremony was one thing, but there was a much bigger issue.
The family tree.
Yes. Sujathamma was 15. Her husband, Hanumanthappa, was 19. But he was also her mother's brother, her maternal uncle.
Which, is an immediate red flag in most legal systems.
It's what the law calls a prohibited degree of relationship, a sapinda relationship. It's generally banned. So the marriage was potentially void on 2 counts, procedurally because of the missing ritual, and substantively because of their blood relation.
But there's an exception, right? The law allows for custom. And her lawyers argue that their community, the Vocaligas, allows for uncle-niece marriages.
They did. But this is where the case becomes a masterclass in evidence. You can't just walk into court and say, oh, it's our custom.
You have to prove it.
You have to prove it with concrete evidence. Show that it's an ancient, certain, and continuous practice. Bring proof of other such marriages in the family or community.
And she didn't have that. Just vague assertions.
Exactly. And that's a critical failure when your entire claim rests on an exception to a federal law. The burden of proof was entirely on her.
Which brings us to the fight between the High Court and the Supreme Court. Because the High Court actually sided with her at first.
It did. The High Court looked at the registered agreement and said, well, the burden is now on the family to prove the marriage didn't happen.
That feels backwards. They were treating it as valid until proven otherwise.
It was a dangerous presumption. And the Supreme Court completely flipped that logic. They said because the very existence of the marriage was in question from the start, the burden of proof never shifted. It stayed with Sujathamma the entire time.
And since she couldn't prove the ritual and she couldn't prove the custom?
She failed. She couldn't discharge her burden. The marriage was declared void ab initio.
And that's such a powerful legal term. It doesn't mean annulled. It means it never existed.
Yeah.
Not for a single second.
Legally, she was a stranger to him. So no inheritance, no status as a widow, a total erasure of their relationship in the eyes of the law.
It's a harsh outcome, but it's a huge warning. Taking legal shortcuts with something as fundamental as marriage, it can cost you everything.
That's the takeaway. Marriage under the Hindu Marriage Act is not a civil contract you can just sign. It's a sacrament. You skip the Saptapadi, you are gambling with your legal status.
Which leaves us with a final thought, doesn't it? As society modernizes, should the law evolve to accept a clear signed intent as enough to form a union?
Or does the state have a compelling interest in preserving the sanctity of traditional rituals? That's the tension we're all living with.
A true clash of eras. Thanks for breaking down this mystery with us on The Deep Dive.